I did.
Okay. So I did draft a journal entry. The proposed journal entry is Exhibit A. I did supply the email that I sent the journal entry, showing that I sent the journal entry to Counsel Mr. Wood. I sent that on Tuesday, May 13th. As you stated, we did have trial on May 7th. I did supply as well, which is reflected in the court filing, Exhibit C, which is Mr. Wood's objections. If you look at the objections, Your Honor, unfortunately, a majority of them are not actual legal objections. They are essentially requests to change your ruling. And I can go into further detail, but I would argue 80% of them are just requests to change your ruling. They're not actual legal objections. And I think that's where we're at a standstill. I was waiting
What
on this hearing.
What about the other 20%?
I
Are there
did
some
make those.
corrections that are appropriate as
I did
suggested
make
by
them.
Mr. Wood? Okay.
So specifically objection 1, 3, 7, 17, and partially 14 were all made. Missing a comma or referencing specifically the parties for joint legal custody. I did make those. But outside of that, the others are requests to modify your ruling. So I was waiting on this hearing to file a motion to settle the journal entry. So that's where we're at on the journal entry. I will wait to go over my objection to the motion if you would prefer that.
All right, guys, buckle up. Today we're diving into a Kansas divorce showdown. Judge on Zoom, 2 attorneys, and a father ready to go rogue. No final decree filed, yet a withdrawal bomb is already ticking. The room's tense before we even talk custody or cash. Every word matters because today sets the blueprint. Miss a detail, you lose leverage. Simple. Watch the judge frame the fight with calm precision. This is where process beats panic. Stay locked in. The stakes just got real.
Once I did that, then I received wording from my client that he was did not approve of what I have objected to, and wanted to know why I didn't use everything that he'd given to me as objections in the journal entry. So I did what I could to pare it down. What really concerned me, though, also is that I filed that on June 3rd, but on his what he had sent back to me, objecting to what I'd sent, he'd started sending copies of that to the disciplinary administrator. And so that concerned me whenever the disciplinary administrator gets involved and indicates that, she didn't want to be involved with that. So I understand the court's position on withdrawing, but I had to put forth the objections that my client in some manner objected to with the understanding that I think some of his objections really would be more of a motions for rehearing or motion for modification. And that's a little bit of a problem when people are using the internet or whatever they're using to come up with attempting to practice law. And so they don't understand the distinctions between those and the objections to the journal entry. The journal entry.
All right, guys, here's the twist. Objections aren't appeals in disguise. Counsel admits small fixes but says dad wants rulings rewritten. That's not how journal entries work. They mirror orders, period. The judge steers back. First finalize the decree, then talk exits. Strategy tip: separate "I disagree" from "the wording is wrong." It's the difference between form and substance. Play it sloppy, get clipped by procedure. Play it smart, you force clarity. And clarity wins.
Doing a job for him, then I just figured I had to withdraw, Your Honor.
All right. Ms. Cooler, I'm going to go back to you for a moment. I trust that there's been some personal communication between you and Mr. Wood in an attempt to try to reconcile differences on the wording of the journal entry, perhaps a recent phone conversation or email chain or something?
I did call Mr. Wood. I did let him know I was going to have to object because we were still in the process of working out this journal entry. You did order for some documentation to be provided to me by petitioner in regards to picking a vehicle. So I said, hey, get me that. We did not go into the journal entry as much. I did let him know, hey, I made some of the cosmetic corrections, but your objections are, or your client's objections are, again, more so for reconsideration, and I'm not going to make those changes. And that was after our Exhibit D, the email including me and Mr. Wood with the disciplinary administrator, where Mr. Presbeal says he is going to file an ethics complaint against me. So not as much as I'm sure the court would prefer, but obviously with this email coming out, I believe.
Buckle up, client versus counsel just went nuclear. For pages of fixes, ethics email CC'd, and Google Law Energy, the lawyer trims the noise, the client cries sabotage. Trust collapses fast when expectations outrun reality. Courts hate theatrics. Facts beat volume every time. Emailing regulators mid-draft? That's gasoline on a spark. If your lawyer won't file it, there's a reason. Ask why, don't escalate. The judge is clocking every move.
To draft an appropriate journal entry of judgment and decree of divorce. Is that correct?
Yes, it is, Your Honor.
All right. Obviously, the comma in number 1 has been resolved. Petitioner objects to the court's finding, and the petitioner will not respect the bond of the respondent. Oh, to the extent, apparently, that the petitioner will not respect the bond of the respondent in this matter. If that's consistent with a ruling from the bench, and I think it is, then
Your
that's
Honor,
not objectionable. Okay,
may I make a statement?
Mr. Presbeal?
Yes, sir.
So-
That's me.
What's your statement?
My concern here is several things in the journal entry are not written how the court ordered. I have recently filed for a transcript request for the judgment in this case. I've paid for that and I have a receipt for it. And a lot of the wording affects the legality of the court's judgment. And when it comes to getting involved with disciplinary administrator, I done that because Mr. Woods failed to address our son getting bit by a dog while in his mother's care, failed to address...
All right, guys, context lands like a hammer here. Arrest backdrop, missed hearing, and a marriage already burning. Exhibit A is the battlefield, words that lock future rights. Opposing counsel flags the disciplinary CC, big yikes. The court narrows in, settle language, then everything else. Precision now prevents chaos later. You don't wing decrees, you engineer them. Every comma can move $1 or a day with your kid. The judge is here to calibrate.
Will not respect the bond of this child with his mother.
That was during my...
And there are other
parenting
reasons.
time.
However, the court finds that the objection is overruled as to number 2. Number 3 apparently has been corrected. As the court recalls, there was a protection from abuse case previously between these parties. The court finds that even though Mr. Presbeal may deny that there was ever any abuse by him, court does find that that's an appropriate finding for the court to make. And the court will
Point of
overrule
order.
objection to number 4. The court also finds that there has been difficulty between these parties based on the evidence to effectively communicate regarding setting a parenting plan or deciding many important matters concerning this child. So the court does
I'm
find that there's
submitting all of
evidence
our
in the
text
record.
messages.
All right, if you interrupt one more time, Mr. Presbeal, we're going to mute you or take you out of the meeting completely. Objection number 6, objecting to paragraph 13 in the school district should be USD 232.
Your Honor, just so you don't have to pull up the, Google it, USD 232 is DeSoto, Kansas, which is
Okay.
up towards Lenexa.
282.
Buckle up, judicial spine on display. Dad speaks out of turn. The mute hammer hovers. Findings stand. Protect the child's bond with mom. Fix communication. Interruptions don't erase the record, they harden it. Courts reward composure, not combat. You want influence. Show restraint. The judge is mapping behavior to outcomes. Today's patience becomes tomorrow's parenting time. It's chess, not checkers.
All right. That appears to be consistent with the orders and rulings of the court as it currently reads. Objection 8. Is there some dispute about the amount of child support to be entered into the record here?
Yes,
Yes.
sir. There's been 3 child support worksheets entered on this without a chance for me to do taxes and submit financial records. And her most recent one states it was filed in, I believe, June 13th
Okay, well,
or May 13th.
okay, wait a minute. Let's back up. Mr. Wood indicated in his objection that I ruled from the bench that I was specifically adopting a particular child support worksheet that called for an amount of $1,383. So why wouldn't that be appropriate, Ms. Schooler?
Your Honor, because you did not adopt a specific worksheet, we imputed Mr. Presbeel's income at $58,000. I think $230. I might be off on the last few dollars, but he was imputed. Correct. And I had to make the tax adjustments, so there was no actual worksheet adopted because I had to make a change. But he was.
All right, guys, naming the school seems small, but labels define logistics, and logistics define lives. Judge keeps West Elk Schools clear, flexible, enforceable. Then we pivot. Child support math enters the chat. Was a worksheet adopted, or were inputs set? If you blur that line, numbers wobble. Courts want arithmetic, not improvisation. Get the inputs right. The total.
I'm ready to file a motion and lay out a lot of things that have gone on here that I believe Miss Schooler and Mr. Woods are discussing and kind of having backroom conversations. Mr. Woods' motion to withdraw on our inability to see eye to eye on this is false. I use a phone recorder, and Mr. Woods previously told me, I believe it was the 10th, that he demanded $7,000, and if I didn't pay, he was gonna withdraw the respondent
Okay,
file.
Mr. Presbeil, be quiet for a moment.
December 20th.
I'm addressing Ms. Schooler. The worksheet that you're depending upon to justify your amount in your proposed journal entry, which is a couple $100 a month higher than what Mr. Wood's objection stated it should be. So where is your worksheet?
Your Honor, I believe because that wasn't a legal objection because you already had ordered for his income to be imputed. I didn't include it, but I am going to pull up my notes from the hearing that I have right here.
Well, that worksheet would need to be filed with the decree.
Right. Because you had already ordered for his income to be imputed.
True.
And
What the court often does, counsel, is to set the building blocks necessary to put the worksheet together.
Buckle up. This is the blueprint lesson. The judge separates building blocks from the final figure. Imputed income, exemptions, taxes. Feed the machine, get a number. And that number must match an attached worksheet. No attachment. Expect turbulence. Counsel hints, $1, $5.69 after inputs. Process isn't petty, it's protection. Follow the steps, win predictability. Skip them, lose credibility.
Once you had adopted all the income numbers and put all the proper inputs in, it came out at $1,569 a month?
I do believe so, Your Honor, yes. I'm going to try to find it in what I sent to Mr. Wood.
And I may have adopted certain numbers out of a child support worksheet that had been submitted. But I think if there were any adjustments that needed to be made to the worksheet for any reason, tax exemption adjustments or anything, then I couldn't have settled or finalized the child support number at the hearing.
No,
That's why
you
I'm
wouldn't have been able to, Your
requesting a
Honor.
transcript.
Because you will see in the my proposed journal entry, you specifically stated, I'm going to find that paragraph for you, that his income must be imputed at that number because he had not provided any income information, and you felt that that was a good number for his trade skills, the kind of work that he does.
Imputed at what number?
$58,320.
That's what your child support worksheet says, but it says date submitted May 13th. The one you submitted on February 12th says 13,833.
All right, guys, final clarity hits hard. Past drafts don't matter. Trial evidence rules the day. Imputed income lands at $58,320, anchoring support math. The court draws a bright line. Facts in, noise out. This is how you close a messy loop. Respect the framework and it protects you. Ignore it and it crushes you. If you learned something today, like the video, subscribe, and we'll see you in the next one.
You have the floor.
Paragraph 29 of my Exhibit A is where I reference you imputing the income, what you imputed at, and why you imputed it that way.
All right. Well, again, Ms. Schooler, it's just difficult for the court to adopt a worksheet number when I don't have the worksheet.
I do apologize about that.
But presupposing that you do have a proper child support worksheet, which places the numbers in that was found by this court to be appropriate at time of trial, if that's how it comes out, that's how it comes out. Now, what did you do with the tax exemption benefits, Ms. Schooler? What?
Your Honor,
What did
he
you
was
contemplate?
given a $203 credit because my client would have been able to claim all 3 children for the year 2024. There is also a daycare cost in the amount of $500 that my client pays. So father was imputed $500 for childcare, and then he was given a complete income tax credit for all 3 children.
Mm-hmm.